For decades, climate change was treated as an environmental issue. But in 2025, Indigenous First Nations Pacific youth and Torres Strait Islanders proved climate change is fundamentally about the most basic human right, the right to life itself. Their legal victories opened a powerful new pathway to climate justice. As Australia prepares to approve decades more fossil fuel expansion, these human rights precedents, centred on the right to life, provide Pacific communities with unprecedented legal power to demand accountability.
We need to keep all new coal and gas in the ground.
3 major climate cases reached their conclusions in 2025. 2 achieved historic victories that changed international law forever. 1 failed completely in Australia's highest court.
The Commonwealth paid scant, if any, regard to the best available science.
In the case of Daniel Billy and others versus Australia, 8 Torres Strait Islanders convinced the UN Human Rights Committee that Australia's climate inaction violated their most fundamental human rights. A group who named themselves Pacific Islands Students Fighting Climate Change took this right-to-life argument global, appealing to the International Court of Justice, where they secured the largest advisory opinion in world court history, with 96 countries participating.
So decided.
But subsequently, in the case known as Pabai Pabai and Polkabai versus the Commonwealth of Australia, the same Torres Strait Islander communities faced a devastating defeat, with Justice Michael Wigney ruling that the government owed no duty of care, despite acknowledging the islands would be uninhabitable within 25 years. Why did the human rights approach succeed, where seeking justice under environmental law failed? Environmental law treats climate change as regulatory failure, but human rights law treats it as a threat to human existence, the most serious legal violation possible. The right to life creates the strongest possible legal obligations. States cannot simply just avoid causing harm. They must actively protect people's right to survive and thrive in a livable climate. Most powerfully, the right to life extends across generations. The International Court of Justice confirmed that present climate decisions determine whether future generations will have the basic conditions necessary for life itself. These legal victories now confront stark political reality. During Prime Minister Albanese's recent Pacific Islands Forum visit, Pacific leaders made clear that Australia's ongoing fossil fuel expansion directly threatens their people's right to life. Australia's coal and gas exports produce more than double the climate pollution of Australia's entire domestic economy, directly violating islanders' right to life by making survival impossible on their homelands. Yet the very day after the Pacific Islands Forum ended, Australia approved Woodside's Northwest Shelf gas expansion until 2070, locking in a shocking 4 billion tonnes of climate pollution. The Climate Council described this approval as a carbon bomb for the Pacific. The contrast between the international victory and the local defeat reveals why strategic legal choices determine everything in climate litigation. International human rights bodies focus on protecting vulnerable populations. Domestic courts focus on traditional legal relationships, often deferring to government policy. It comes down to the legal framework. Environmental law asks, did someone break the rules? But climate change isn't that simple. The climate is changing fast, and tort law has been slow to catch up. Human rights law, on the other hand, asks, is the government doing enough to protect its people? And that's a far more powerful question when seas are rising and islands are becoming uninhabitable. Human rights law gives Pacific nations 4 clear ways to hold others accountable. First, people can bring individual complaints to UN bodies, arguing that climate change threatens their right to life under international law. Second, countries can take each other to the International Court of Justice, claiming that governments are failing to protect their citizens from life-threatening harm. Third, regional agreements can treat climate change as a serious threat to peace and security, just like a conflict or natural disaster. And fourth, governments can be challenged for not protecting their people from harmful actions by corporations that contribute to climate damage. The right to life pathway to climate justice recognises what environmental law often misses. Climate change is about human survival. It threatens the most basic condition for all other rights: being alive. The legal precedents are clear. The right to life is absolute. Pacific communities now have the ultimate legal argument